All right. Hello, everybody. Thank you for joining us tonight. We have Adam Bartsch here, who is an attorney and specializes in estate planning, which is always a topic of great interest, not only to us, but to most of our clients. And I'm going to let this person in as well. So hold on one second, and then I will read the disclosure and then give a little bit of background on Adam. Oh, we have a couple more joining us. See, I clicked the button a little too soon. Could have waited a minute. There we go. And Hans. Hi, Jean.
Hi.
How's it going?
Good. And with you?
Very good.
Busy time of year?
It is a busy time of year. All right, and Hans is connecting right now. So I will go ahead and read our fund disclosure, which is that Clue Wealth Management and LPL Financial do not provide legal advice or services. Please consult your legal advisor regarding your specific situation. And Adam Bartsch is not affiliated with or endorsed by LPL Financial and or Clue Wealth Management. So now that we got compliance out of the way, all right. So Adam, I am going to turn it over to you now in order to talk to us, but I would just like everybody to know that you are licensed in both Vermont and New York and do business both places, and your background is estate planning. You have some interest in charitable as well, but you don't have a lot of people writing up trusts, and you've been doing this for a number of years, and you are in a solo practice, and business has been very busy the last year at least.
Yes, it has been. And while we're on the focus of disclosures, let me just say that this is not legal advice. I will give you general information, but nothing is meant to be specific to your situation unless you meet with me individually. I've been doing estate planning since 2004 in my own business, Northeast Estates and Trusts. What I wanted to discuss tonight is the real basics of estate planning, because a lot of people are intimidated by dealing with an attorney and they don't know what they're getting involved in, and it seems much bigger than it is. And there's just a lot of reasons not to do estate planning. Not to mention that you're effectively, one way of thinking about it is your death planning. And death planning is not something that people think of it fondly of. Nonetheless, everyone should have an estate plan. And when I say estate plan, I'm not focusing on estate, I'm really focusing on planning. People hear estate plan and they think, oh, that's only for rich people. It's really not the case. Everyone should have an estate plan. Everyone, that is, who is probably married or having children. Before that, you need real basic incapacity planning, but I'll talk about that in just a minute. So let me first say why it's important to have an estate plan. If you don't have an estate plan, and supposing you get injured to the extent you're incapacitated, you're not going to have someone to pick up and run your financial life for you on short notice. You might have to go have a guardian named for you. A guardian is, in Vermont at least, it's a court proceeding. It's quite involved. It's much easier to have a power of attorney. So you can have I'm talking about incapacity planning now, and this is pre-death planning. You probably want a power of attorney. You probably want a HIPAA release. A HIPAA release says these people I've listed on this form have access to my medical information. So if you end up in the hospital can speak to those people. Otherwise, the hospital isn't even supposed to speak, isn't even supposed to say that you're in the hospital if a family member calls up. Even if you're married, a spouse does not have access to your medical information unless you have provided it to them. Now, very few people realize that, and the reason for that is spousal abuse. It's kind of a big deal because if you call up the hospital and say, is my husband there? The hospital shouldn't even tell you whether they're in the hospital or not, because that's the unauthorized release of medical information. So without having some planning in place, you risk making things much more complicated than they need to be. Similarly, on the death planning side of things, if you don't have a plan, then the state has a plan for you. Now, that might be a good plan, it might not. The thing is, you can override that plan and have your own unique plan, and that just makes a lot more sense. In the state's default plan, typically everything passes to your spouse, unless you're on a second or third marriage, which gets a little more complicated. But if everything doesn't pass to you, if you don't have a spouse, then everything will typically pass to your children. And if you have no children, it will typically pass to your parents. And if you have no living parents, then it goes to your sibling and nieces and nephews. Now, that might be what you want. It might not be what you want. Again, a little planning can go a long ways. So having a plan in place can squeeze out all the uncertainty. One of the things I try and do is make things as certain as possible by putting everything in black and white. So we are trying to eliminate ambiguity. We're trying to eliminate uncertainty. We're trying to eliminate beneficiaries who are surprised later, because we really don't want any surprises, because that leads to litigation and that leads to needless expense and heartache and everything else that goes with it. Another reason to have a plan is because you want to name the people who are in charge. You want to name the executor who's going to manage the probate process. You want to name a possible trustee. If you don't name these people, someone's going to stand up and say, I should be that person. And that might not be the right person for you. Coming back to the documents you might want to be thinking about. Again, I'm going to start with incapacity planning. There's 3 documents everyone should have. There is a power of attorney for finances. There is what in Vermont we call an advance directive. I've done these in New York. I'm just not sure what the exact name is, but it's effectively the same thing. An advance directive is where you are naming someone to make medical decisions for you. And by medical decisions, I mean acute hospital-based medical decisions. So the advance directive, also known as a living will, is a very limited document. The power of attorney for finances is also a power of attorney. You're naming someone to make decisions for you, but it's everything else that's not the medical power of attorney. So it's far broader, and for that reason, far more dangerous. Because with a power of attorney, your agent can sell your house, they can take your money and go off to Tahiti, they can do all kinds of bad things. You want to be certain that the person you're naming as your agent is someone you can trust 110%. Because while they are supposed to do the right thing for you, if they don't, a lot of damage can be done. And lastly, the 3rd document you want, I've mentioned the power of attorney for finances, the advance directive. The 3rd document is the HIPAA release. I talked about that a little bit already. That's simply authorizing medical personnel to talk with people about your situation when you are incapable of expressing who you'd want the hospital to talk to. Is all that fairly clear? So that's the pre-death planning, also known as incapacity planning. When it comes to death planning, we're thinking either a will-based plan or a trust-based plan. And this is where people start getting intimidated. Attorneys take different views on this. Some attorneys really want to do a trust for everyone. Some attorneys who are not estate planning attorneys want to do a will for everyone because a trust is more than they can handle. My approach is the will is the default plan. If people have a good reason to have a trust, then we'll do a trust. I do about 20% trusts and about 80% wills. And that's because most of my clients don't need a trust. That's not to say there aren't good reasons to have a trust. And let me run through some of those. One is if you have a lot of money. Both Vermont and New York, I think New York may have reached the federal exemption amount right now. It's up around between 5 and 6 million. I should qualify that statement because right now on the federal level, that is doubled. On the federal level, you can pass 11.7 million per person with no questions asked. That's the amount you can pass before you must file an estate tax return. New York is, I believe, between 5 and 6 million, and Vermont is 5 million. So if you have less than that amount of money, you don't have an estate tax concern as of right now. The laws can always change, but historically, taxes have been the number one reason why people have trusts. And the reason they do that is to protect both spouses' exemptions. Because if you're a married couple, you each have an exemption. And the danger of having a will-based plan there is you say everything to my spouse. One of the spouses dies, the surviving spouse ends up with a combined estate. And if that's more than one exemption level, you are exposed to the estate tax. Historically, the exemption levels, what's known as the exclusion amount, was much lower. It was 675,000, and then it started bumping up through the 2000s. And finally, in the 2017, we ended up with 5 million index for inflation doubled. So that's how we got to 11.7. Now that 11.7 is going down to about 6 million in 2026. So I don't want to get too wrapped up in taxes here, but my point being, most people don't have an estate tax concern. So that's off the table for most people. Nonetheless, there are good reasons to have a trust. One would be if you have a blended family. A blended family is where you have children from outside the marriage, and you run into a similar problem there. If you have a will-based plan, you're typically saying everything to my spouse. And despite the surviving spouse's best intentions to not disinherit the children from outside the marriage, that too often happens. Even if the spouse and the children get along phenomenally well, after about 10 or 20 years, those bonds are not so tight. And by that time, the surviving spouse is thinking, I would really prefer my children to have the money, not these children from my husband's prior marriage. So even when people come to me and say, oh, that's not an issue, realistically, it is an issue. So if you have a blended family, that's a reason to have a trust. If you have a special needs child, that would be a reason to have a trust. Special needs children are typically receiving government assistance of one sort or another. And if they inherit a chunk of money, they risk losing their government assistance. So what we can do is we can have them inherit money that does not displace the income of the government assistance. It's a fairly simple thing to do, but you do that through a trust. You do it through what's known as a special needs trust. If you have a child who's not good with money and you're concerned that they're going to just blow a lump sum, a lump sum inheritance, that's a good reason to have a trust. Example, if it's a couple $100,000, that's one thing, but if it's a couple $1 million, that's too much money for some young people. And they're going to be hanging out with the wrong people, and that money is going to get wasted pretty quickly. So trusts offer a lot more flexibility when it comes to deciding how much and when children can access the money. And if you want to be really, really cautious, you make them go to a trustee every time they want the money and say, please, may I have the money? And they have to demonstrate a good reason. So I'm not recommending that, but that's one option for children who cannot handle money as well as perhaps they should. Another reason to have a trust is real estate in several states. Wherever you own real estate, you're probably going to end up going through probate. So if you can bypass that, it's never a bad thing. So if you have real estate in 2 or 3 or 4 different states, you might be looking at a trust. If you have a family business, you often don't want the family business going through probate because sometimes the business is unable to make decisions and move forward as they should when a court is overseeing some of their actions. So it's often a good idea to, if you have a family business and it's the principal money generator, in order to keep that out of probate, you will often have a trust. And also some people are just concerned about probate in general. There were some books written back in the 1960s and 1970s that really scared the wits out of people when it came to going through probate. They really convinced everyone that probate is an awful thing and you should avoid it at any cost. I can say that in Vermont and New York also, I believe, probate is not a good thing, but it's not a terrible thing either. It takes too long. It might cost a little bit too much, but it's not nearly as bad as people think it is. In fact, I go through probate all the time, and it's become very highly, it's very efficient. It's done online now. We have a good judge here in Chittenden County who moves things along. Some counties have not so good judges and things can go on forever. I have a probate up in the Northeast Kingdom since 2011. Two sisters who hate each other. They can't figure out how to make it work. The judge is not paying attention, so nothing's happening. So probate, in my opinion, is not something to be avoided at all costs. Again, about 80% of my clients have a will-based plan. And if you have a will-based plan, you're probably going to end up in probate. That being said, oftentimes you can stay out of probate even with a will-based plan. Because what you're doing is you're adding a beneficiary designation to your accounts, or you're adding a transfer on death to your accounts, or a payable on death, or a in trust for designation. All these designations added to your financial accounts, your retirement plans, your life insurance, that makes all those accounts go straight to the beneficiary and it avoids probate. So I have a number of clients who have gone with the will-based plan, but we're putting every account, we're managing it so that nothing's going to end up in probate anyway. Even the house, we can keep the house out of probate through something called a ladybird deed. So I don't want to say probate's a good thing, but it's not as bad as people think it is. A reason for a will-based plan is to keep things as simple as possible. A trust-based plan is more complex. It's more expensive. It's harder to wrap your mind around. I can often work with clients and get a trust-based plan together and they understand it. And then they come back a year later and they only have a vague idea of what they've done. And what I've learned over the years is people really want to keep things as simple as possible. So I try to meet that desire by keeping my plans as simple as possible. Einstein had a great saying. He said something along the lines of, make things as simple as possible, but no simpler. And that's good advice. Keep it simple, but don't get sucked into forgetting that some things cannot be overly simplified. So the point being, some people need a trust. If your situation is complex or you have a lot of money, you very well might need a trust. But where we can, we try and keep things as simple as possible. Some mistakes you ought to try to avoid. And by mistakes, these are things people talk about over their back fence with their neighbor. Oftentimes, the neighbor doesn't know anything. They've been through the experience and they've heard something and they figure, well, if it was good for them, it must be good for me. And these things happen way too often. And I'm going to run through a few of them. The first thing is adding a child to your deed of your house. That's just a bad idea. What can go wrong is the child gets into a car accident. They are found liable to the other person, and that creditor is coming after your house. They are going to take away half of your house. And what that means is the house is going to be sold. The creditor gets half the proceeds, and you are left with half the proceeds, but no house. So there are easy ways to avoid that. It's in Vermont, Some people call it the default estate plan. It's really not a good idea. So if you've done that, think twice. And if anyone's suggesting that's an easy way to avoid probate, think twice about that too. Another mistake is not keeping your accounts updated with beneficiary designations and the like. This is a really simple thing to do. Financial advisors will typically do it for you on your investment and retirement accounts. And your bank accounts, you simply need to visit the bank and say, this is what I want to do. And they will do it for you. It avoids probate. It's really very simple. There's not a whole lot to be said. You take an account, you bypass probate, goes straight to the beneficiary. The only place you really don't want to do that is when you have young children, your husband and wife, and maybe two very young children. So in that case, you might want to have the proceeds, the assets and the accounts pass through probate, simply because you want the assets to end up in a simplified trust for the children. And you don't want to be naming the children as direct beneficiaries, because then the money is just too readily available. Minors cannot inherit money. So in any event, there would be someone between them and the money. But if it's in a simplified trust, it's going to maybe be, the access will be deferred until maybe they're 25 or they're 30, so that they are not blowing the money when they're too young. I mentioned unintentionally disinheriting your children. I'm just going to revisit that for a minute. And this is how it happens. You have a blended family. You have a will-based plan. You say everything to my spouse. Spouse does not include your children from outside the marriage in their estate plan. But because in your estate plan, you said everything to my spouse, you've lost control. Now, the way to prevent that is to have a trust such that you can leave access to the funds to your surviving spouse. But when your spouse passes on, those funds have to go to your children. Well, they don't have to go to anyone, but they do have to go to the person that you've named as the beneficiary. So it's locking it down. It's a little more secure. It just makes sense. Having inadequate insurance is another big mistake. I'm a big fan of umbrella policies. Umbrella policies add a lot of protection for people, for homeowners principally, but the umbrella policy also typically covers your vehicle. And as you get older, you're more likely to be in a vehicle accident than to have a slip and fall on your residence. So slip and falls are what people think about, but causing an accident in a vehicle is much more likely. And if you cause an accident, your standard policy is not going to go too far. You can buy a very cheap and effective umbrella policy through your homeowner's policy and have a lot of additional protection for about $200 to $500 a year. Anyone who comes to me, almost anyone who comes to me, I'm recommending they buy an umbrella policy. Now, there's other forms of insurance too, but that's the easy one. There's long-term care insurance. You might want to be thinking about life insurance and all that. For asset protection, I'm looking at an umbrella policy. Failing to plan for incapacity. We talked about that some. You just need some basic documents. It's not complicated. You just need to be naming people who can manage your life while you are incapable of doing it. Pretty straightforward. You just need to pick people you can trust to do the right thing. If you don't plan for incapacity, that stretch of incapacity is going to be a lot more difficult. There's just no two ways about it. Failing to keep your plan updated. Supposing you've done your plan, most clients view it as okay, check it off the list. I'm done. I can forget about it. That's a real problem because 15, 20 years goes by and what you did 15 or 20 years ago does not reflect what you want now. Or there has been a death in the family or a birth in the family that has not been accommodated. So it's really important to keep your estate planning up to date. Attorneys handle that in different ways. My way of handling that is to offer clients a free annual meeting. So clients can come in once a year and say, this is what's happened on my end. And I can say, okay, this is what's happened on the state and federal side of things. If they decide that they need an updated plan, I will charge for the updated plan, but I'm not charging for the meeting. I do that because I want them to feel comfortable coming in and updating the plan really as often as they want. Most clients don't come in every year, but I want them to feel free to come in and tell me what's changed. The last big mistake, and this isn't not a mistake for everyone, but going to Staples and buying something off the shelf, or maybe doing LegalZoom. I can tell you, I make a fair amount of money on people who have done LegalZoom, and I charge by the hour for that kind of work. Most of my pricing is set fees, so people know what they're getting up front. But when it comes to cleaning up a mess, I charge by the hour because there's no telling how long it's going to take. And the problem with LegalZoom is that deep down, you don't know what you don't know. Meaning the choices you are making that you don't understand the repercussions. And if you put something on paper and sign it, you're going to be held to it. And the fact of the matter is, you're not going to know what's wrong until after you die. So your survivors are going to be left with a situation that sometimes makes no sense whatsoever. And cleaning up that mess is expensive. So unless your situation is as basic as they come, I'm not a big fan of LegalZoom. One last thing I want to talk about, and then I'm going to open it up for questions. When it comes to looking for an attorney, word of mouth is really the best way. Talk to your friends, see who they've used. If you are not able to locate an attorney, there's some organizations out there that you can look at on the web. I'm a member of Wealth Council. It's an organization of estate planning attorneys, and they have a locate an attorney feature on their website. There's also some organizations, ACTEC, ACTEC is one. That's principally for higher end attorneys who are serving clientele who either have a tax concern or who have more complicated planning. There's also an organization called National Association of Elder Law Attorneys, better known as NAELA, N-A-E-L-A. This is a group of attorneys who do a lot of planning oriented at seniors. And it can be estate planning, it can be Medicaid planning, it can be really anything that seniors are dealing with. It can be guardianships, it can be protecting against, abuse of whoever it might be. So NAELA is a good organization. All these organizations have find an attorney buttons on their websites. So if you don't find someone through word of mouth, look at one of these organizations. As I mentioned, I do fixed pricing. I think it's only reasonable for most clients to understand what they're getting into before they sign up. You want to get a sense of what the price is going to be, and you want to get a sense of what the process is going to be. As I was saying earlier, a lot of people start the estate planning process, and then they get bogged down for one reason or another. So sometimes the estate planning process can go on a couple of years, unfortunately. Sometimes it goes very quickly. It really depends on the client. But you also want to make sure that the attorney is capable of moving things along at your pace, because we really typically move at the client's pace. Some clients, I've had people call me up on a Friday and say, we're flying overseas on Monday, can we do something? And yes, we can. It's not a good idea because we're probably going to make some mistakes, but it's better than nothing. So yes, I have done that, but I don't like to do it. It's really just not a good idea. Lastly, you want to find an attorney who spends at least half their time in estate planning. If they are if they're the attorney you bought your house with, they might not be the best estate planning attorney that you want to reach out to. It's kind of like going to a doctor. if you have a specific medical issue, you don't want to just go to a family practitioner who's going to handle everything. You want to go to them first, but then you want to find someone who really knows what they're doing. And it's the same thing in the legal field. Whether you're in bankruptcy, whether you have a litigation matter, whether it's estate planning, you want to find someone who spends most of their time in that field. So my advice is don't just go to the friendly attorney you've known for the past 20 years unless they are an estate planning attorney. And that wraps up my thoughts. I'm happy to answer any questions you guys have.
Thank you so much, Adam, for all of that information. There was a ton in there. Before we open it up to questions, maybe it would be helpful for everybody if you repeated those 3 resources that you named. Yep. Would you mind giving those again, please?
Yeah, the first one is Wealth Counsel. And that's Wealth Counsel, COUNSEL. That's a national organization of estate planning attorneys, of which I'm a member. There's ACTEC, ACTEC, principally for higher end clients who are either more wealthy or more complicated. And there's NAELA, NAELA, directed at the senior crowds, mostly serving senior needs, who include estate planning, but often do other things too. And all of them can be found on the internet.
Perfect. Really appreciate that. So I know I have a bunch of questions, but I'm not going to monopolize the time. We have this for our clients, so let's open it up to any questions out there, any comments. And I know there was a lot, and it really came across why it's so important for everybody to have a plan. Anybody want to take a stab at it? Go ahead, Jean. You don't have to raise your hand. You know, go ahead.
If you go to one of these organizations to get the estate planned and you've got everything, and then about 5 or 10 years down the road, you get it updated, who do you go to?
Well, I'm not suggesting you go to the organization to have the organization do the work. What I'm suggesting is you go to the organization to identify an attorney locally who can help you. So ideally, you're not going to work with an attorney who's 75 years old. You're going to work with someone in maybe their 30s or 40s or 50s who's going to be around for 20 years, who will be there for you. I don't have anything against 75-year-old attorneys, but
thank you for adding that in.
the idea is to establish a relationship. So the idea would be to find an attorney you like and stick with them.
So Jean, those were more of a resource in order to find yourself an attorney. It wasn't an organization for you to work with. Does that make sense? Okay. All right. Anybody else out there with a question? Janice, I didn't get to say hello when you entered, so hello. Okay, well then I'm going to ask a question. Let's see, which one do I start with? How often do people tend to change their wills? I know you mentioned that you offer a free annual meeting. 1, do people actually take advantage of that? And then 2, how often do you see people actually changing or updating their wills?
That is very client-based. I have some clients who are changing their plans every couple of years, and it really surprises me because, unless they enjoy the process, I'm not sure what they're doing. But some people change it frequently, and other people, I work with them once and I never see them again. The majority of people are not changing their plans all the time because their situations are fairly simple. And unless a family dynamic changes or something, they don't need to update their plan. So for the vast majority of people, I'm not updating their plans really very much at all. In fact, a lot of people don't even make an effort to come in for the annual meeting. They have their plan.
Exactly what I thought.
They have their plan in place. They're comfortable with it. Nothing has changed. And, they're okay with that. I will say things do change on the state and federal side of things. So it's not a bad idea to come in once every now and then. But it's really very client, all the clients are different. I am surprised at how often some come in, but It is what it is.
Oh, Heidi, go ahead.
I have a question. A lot of our clients name powers of attorney, and they don't, or executors or trustees, and they don't ask permission of the people they're naming. They sometimes find themselves in a predicament where they name somebody as trustee because maybe they're the oldest son or executor or healthcare proxy agent. Instead of naming the nurse, they name the oldest son, and then it ends up being a cat match. What's your guidance for clients when they select their professional fiduciaries, whether it be a CPA, whether it be a power of attorney, whether it be a executor or a trustee? Do you recommend that they consult with them and ask permission?
When they are comfortable, yes. And it kind of depends on the role of the fiduciary. For example, a guardian for a minor child is an absolute must that they talk to the people who might be raising their children. That's a no-brainer. When it comes to the power of attorney for finances and maybe the trustee, I recommend it. Some people do, some people don't. I think it's a good idea to, unless there's some reason not to. On that same kind of thread, I also recommend parents talk to their children about their estate plan unless there's a reason not to. Again, I mentioned earlier, we want to keep surprises to a minimum. So the idea is to let the kids know in a general sense what's coming down the pike. Because we just don't want kids being surprised. And sometimes people, instead of coming in for the annual meeting, I'll have what's known as a family meeting, where I have the parents and the kids come in. I talk to the parents beforehand about what they want me to talk about and what should not be talked about. And then we'll have that family meeting, and that just kind of greases the skids for later so that everyone's kind of on the same page. I think, honestly, that goes in line a lot with your question. If we can avoid surprises by talking to people ahead of time, that's the best thing we can do.
A lot of our older clients have kept everything tight to the chest. They don't have these family meetings. They don't want their children to know how wealthy they are. At those meetings, do you divulge their net worth, or is it more of a servicey overview? Here's your roles and responsibilities.
Well, it depends on the parents. And I have to say, I don't have a lot of these family meetings. I do offer them, but not a lot of people take me up on it. I will talk to the parents ahead of time and say, okay, how deep do you want me to go? Some families are just wide open. They want everyone to know pretty much everything. And then other families are entirely different. I will say the more cautious families are not showing up for the family meetings. It doesn't come naturally to them. And that's fine. I want to let the kids, particularly in a blended family or a situation where you might have, family members who are close, but really maybe not that close. We want to avoid surprises later, is what it comes down to. We want to let people know.
What would you identify as a surprise? Like all of a sudden your parents are multimillionaires, or is it the surprise that you're disinherited? What surprises are you dodging?
Mostly it's unequal distributions or something of that sort, where kids are being treated unequally.
Okay.
And that can be for good reason. Oftentimes you'll have a very wealthy child and you'll have a not so wealthy child. And the wealthy child doesn't need the money. And for that reason, you have an unequal distribution. It can be to understand the process that happens after the death of the parents, whether it be probate or trust administration. I guess it's just informing the kids about what's coming down the pike, what they can expect. So there's less uncertainty for them and everyone else.
Thank you.
We also do the family planning meetings as well. And very interestingly, same thing, we have the conversation ahead of time, whether the person wants to share any information or how much. And I think that that's a great place to start. My mother's personal plan, by the way, when we were growing up was, if anything happens to me, you and your sister go live with your grandparents. That was it. Nothing in writing. And who is going to listen to children, right? So don't follow that plan. Like that, it was awful, absolutely awful. Any other questions out there? Go ahead, Janice.
Can you hear me okay?
Yep.
Okay. I have a question about choosing or naming trustees. We're not too far along on this, but it's kind of a two-part question. Let's see. The first part is, can we name a series or 2 or 3 people, like here's number 1 trustee, and if that person can't do it, then here's our other choice or something. And then the second part is, after discussing this a little bit with my lawyer brother-in-laws, they said, oh, don't name so-and-so as your trustee, our nephew, who's very responsible and we trust, because it'll be such a pain for him and blah, blah, blah. And it will be really hard work. So is it really hard for the trustee to do all that stuff? And can we name more than 1 trustee?
So the easy answer is yes, you can name more than 1 trustee.
Okay.
And honestly, when it comes to any fiduciary role, whether it be trustee, executor, guardian, agent under the power of attorney, advanced directive agent, you're going to name a primary, and then you're going to name a backup, and you might name a backup to the backup just in case.
Okay.
You always want you always want the number 1 person and at least 1 backup.
Okay.
Because you just don't know. When it comes to too much work, that depends on a lot of factors. It depends on the estate. It depends on the capability of the individual. I will say, when I started my business, I was more partial to individual trustees. I had become a lot more partial to what they call corporate trustees over the years, because there is a lot more that goes into being a trustee than people recognize. There is the handling of, and I should back up a second. A trustee can bring in professional help. They can bring in an investment person. They can bring in a CPA.
Okay.
Oftentimes they don't. They try and do too much on their own because they're well-intentioned and they don't want to be spending the trust money on a professional and everything else. But people, you need to pick a trustee who knows when to seek professional help. Because if you don't, you're asking for trouble. Doing the trust tax returns, that's a big deal. There's a specific tax return for trusts, and they get filed every year. I'm not talking about when you are creating a trust for yourself, but after you pass on, if the trust continues, that trust has its own EIN number and it has an annual tax return. So yes, there's a lot involved. That being said, there are a lot of families who have an adult son or an adult daughter as the trustee. And with the right professional assistance, it's a doable thing.
Okay.
So it really depends on the family. I wouldn't say one or the other, but if you're hesitant, I might lean towards a professional trustee.
Okay. How do you find professional trustees?
Where are you in New York?
Yes.
I can't say I know New York as well. But a lot of banks have professional trustees. There might be some trust companies. Christina?
I'm sorry, what?
No, go ahead, Heidi.
Oh,
We can offer up some thoughts and suggestions on professional trustees. And if you want to name a person and say that person says, I don't want to do it, which I've had clients name trustees bow out because maybe their health is not good, their job situation, they're living overseas, or they just don't want to do it. Then you can have a default as a second, third, or or a primary as a professional trustee.
Okay.
So
okay.
we can talk about that and give you some more information.
Okay.
I totally agree with the default plan, having a person, and if they don't want to handle it, maybe a backup corporate. The one thing to keep in mind with a corporate trustee is you want to ensure that they can be fired. Usually that's by the beneficiary, but it has to be someone, because if the corporate is just dragging their feet and being very difficult, you want them to be able to be fired. Once someone has the capacity to fire them, they're going to be more responsive.
Absolutely.
Okay.
You always
Okay.
want to have control of who's at the helm.
Okay, thanks.
Great question. Anybody else out there with a question?
I do, Christina. It's
Sure.
Juanita.
Go ahead.
Uh,
Go ahead.
Thank you. You mentioned a primary, and I think it was either a backup or a secondary trustee. Do they have the same privileges of that trust, or is the primary the one that, has control of everything?
So I'm not talking co-trustees. I'm getting an echo now, but when I say having a primary and then a backup, I mean having a number one, and if they're not available, the number two steps in. And if number two is not available, number three steps in. So it's not all the trustees having authority at once, it's only one. Now, the alternative is to have co-trustees, which I generally shy away from. It brings in some hassle factor to have more than one trustee. It's not a bad idea. It's often not the best idea. And I particularly do not like co-agents for the advanced directive or the healthcare proxy. If you get two people involved in that, you're looking at inertia. Nothing's going to happen. And that defeats the purpose of having the healthcare proxy. And also with the power of attorney for finances, you can have two agents, but that just gives institutions more reason not just to kind of slow things down and not get anything done. Institutions don't like powers of attorney, so they're going to come up with a bunch of reasons why they should not have to honor one. And if they can say, well, only one trustee showed up or one agent showed up, well, it just makes things more problematic.
And it's ugly when they disagree.
That too.
We have run into situations where banks don't want to recognize a power of attorney, and that is very disturbing. Juanita, do you have sorry, go ahead, Adam.
No, I was just going to say, I ran into that with my sister recently. The bank came back and said, well, it wasn't notarized correctly. No, that's just absurd. It was done correctly. They just didn't want to honor our wishes. What can you do? I mean, they can stall, and then it's too late.
Agreed. Juanita, do you have a follow-up question to yours? Did that answer everything?
That answered it. I just got to check the trust to see if it's a co or a primary. So I'm a little concerned there. Yeah.
Okay. Thank you.
And sometimes if you link the power of attorney to the bank accounts, should you want the power of attorney to have the control at his client's age, it's sometimes a good idea. You'll then know whether the bank is going to accept it or not at that point in time.
Yeah, I totally agree. And I often encourage clients to bring their agent to the bank with them, because agents are often children. And if you can walk into the bank and say, this is my agent, say hello. And then because when we don't live in New York City, we're probably going to see the same bankers 5 years from now that we're seeing now.
Mhm.
So if you can establish that relationship, that might go a long ways to eliminating this problem.
Adam, a quick question about the HIPAA release. Do you draft that for people at the same time that you're drafting the wills, powers of attorney, advanced directives and everything? Okay, so that's something that they get from the attorney, not necessarily from the hospital?
You can get one from the hospital, but it's going to be specific to that hospital.
Okay.
Ideally, it's better to have a general HIPAA release, which is, it's based on federal law, and it's good wherever you go. So It's not bad to have more than one HIPAA release. You might have one general and then have one specific for the hospital. Because sometimes institutions will just be difficult. But there's nothing wrong with having a general.
Can you have that added as in part of the power of attorney, a special paragraph of HIPAA release?
In the power of attorney?
Yeah,
In the advanced directives?
power of attorney.
No, power of attorney. I suppose you could, but I think the hospital is going to turn around and say, this isn't a HIPAA release, this is a power of attorney. What are you talking about? I think you're just adding confusion to the matter. When
Because I've
it's-
actually seen those, that's why I ask.
Yeah, I don't see any reason why you couldn't. I just think maybe you're adding an element of confusion that is not going to serve you well,
Fair enough.
It may not be recognized.
possibly.
Yeah, okay.
I mean, if you walk into the hospital with the power of attorney, they're going to say, why are you showing us a power of attorney?
Oh.
I mean, they don't do powers of attorney. They do advanced directives and HIPAA releases.
Sure.
Hmm.
Any other questions?
Just quickly, one more time, what is the HIPAA release? It authorizes the medical personnel to discuss your condition, or
What you're doing is you're authorizing certain people to have access to all of your medical
Oh.
records.
okay.
And that includes talking to doctors if you're incapacitated. I will say HIPAA releases can be sometimes too broad in the sense that if a client has some skeletons in their closet, you are opening the door to someone looking into your past. So, if and I'm not talking about anyone in particular, but if you do have skeletons in your closet, you might tailor your HIPAA release and not just have it a general release.
Okay.
As a general
That's
release,
an interesting point.
the general release has psychiatric, it has medical, it has everything.
Thanks.
When you were talking about powers of attorney and naming secondary or tertiary in some cases, so if you have a situation where usually the spouses are each other's primary power of attorney and both of them are not in a place where they can really act for themselves, let alone the other person, what is needed to make that secondary the primary in that instance?
Yeah, simply some sort of documentation that the primary is unavailable. Now, in my powers of attorney, I have 3 situations. I have two doctor's letters. Well, let me back up. This is regarding incapacity, how you determine incapacity. But the same would be the case for the agent. If the agent's unavailable because they're incapacitated, it's essentially the same thing. So you have 2 doctor's letters. And in this case, if both people are in the same hospital, it's a pretty clear thing. You also have a court determination that someone lacks capacity, or you have a whereabouts unknown. And I refer to that as my, hiking in North Korea, and people just don't know where you were and they can't locate you. So if you're the agent and you've gone hiking in North Korea and no one can locate you, that's a good enough reason to move to number 2.
What happens if they just don't want you? Can they
Well,
can
they
they
can
sign
always-
a form?
They can always decline.
Okay.
In all of these roles, people can decline, which comes back to that trustee question. If you name an individual and it's too much for them, they can up and decline, which it probably is best for everyone.
We've been in the situation where we have a power of attorney and they've done a good job. They've made it what I like to refer to as evergreen. They have a primary, secondary, and a tertiary. Then all of a sudden the primary, which is probably a loved spouse, is on early onset of dementia, and they don't want to go through the emotional upheaval of declaring them incompetent or having doctors certify they're incompetent. So then they just end up resigning. So is there any other way to go about it other than, agent unavailable? You'd have to kind of prove that.
Well, if they are, you know, a year or two into Alzheimer's and they lack capacity, then they cannot resign.
Right,
But
but
if,
if the attorney will accept their resignation because they know that they understand it, then that's the often the way to shift to the second person. That's least painful for the husband and wife couple.
I couldn't agree more. I mean, that's, you know, we're not looking to make things complicated here. If that's the best way and that's the easiest way, I wholeheartedly agree.
We are down to 4 minutes, it looks like. Does anybody have any last question to close us out here? No? Okay. Well, thank you very much, Adam, for talking to us today about the importance of a plan and lots of information. Yeah, I saw Janice clapping. Absolutely. Great job. If anybody has any questions for you or wants your contact information, please feel free to let me know and I would be happy to pass it on for you. And of course, we'll have your recording on our website at some point so then they can hear all of this again. And I hope everybody had a happy Thanksgiving. I should have said that at the beginning. So, and Merry Christmas and a Happy New Year as well, because the next time we see each other will be 2022, which is absolutely insane. But thank you very much, Adam.
Welcome.
Thank you,
Thanks,
Adam.
everyone.
Excellent
Thank you.
job.
Thank you.
Thank
Have a
you.
good night. Have a good night and happy holidays.